he basically concedes all of Andrew's analysis on the counterclaim. We're going to be able to win 100% solvency here. He only says to McKinnon and Evans says that the counter clause is key, but Andrew's analysis just is on point, saying that VAWA would, all the cards of VAWA should all to be implemented. The counterclaim captures that. Additionally, the warrant to that, he concedes that the warrant to that argument is that we have to be brought out of the public sphere. We do that as a result of the equal protection clause. As a result of the equal protection clause, his analysis is fundamentally not true. Our argument is that we reinterpret the 14th Amendment to apply it to not specifically state action. That is the way the counterclaim functions, which means we solve that for any of the warrants there. He said the permutation says to both, but he concedes the analysis to why the warrant of McKinnon Evans is that this would be most palatable to the Supreme Court. This is the most narrow interpretation when you combine the two, which means it does not solve for any of the implications isolated in the rest of the round. Second argument, it doesn't solve the racism arguments because it is so narrow. Our argument evidence specific as to why having a broad interpretation of 14th Amendment protections, i.e. saying that the 14th Amendment state action doctrine is fundamentally wrong and it ought to be applied to individual citizens is the only way to solve for racism. It's the only way to mobilize groups, human rights groups, and the only way to change the racist policies. The point where that's gets conceded argument, that means I get the co-valent back evidence that's racism leads to extinction. There's no way the permutation would ever be able to solve this analysis. There is no, additionally, they can see that they fundamentally still link to the fundamentally still link to that benefit because they still commodify people and still view things in economic terms. The permutation does not get them out of anything. He drops out of the federalism debate and he agrees with evidence to say accept the federalism debate, but yeah. His answer, his argument here is that it's not constitutional right now. No kidding, neither is the Commerce Clause right now. The point of running the counterclaim is to reinterpret whether the 14th Amendment applies. And this aspect does not apply to things that are not state action. In the world of the counterclaim, it does now apply to things that are not state action, which means we reinterpret the 14th Amendment to be able to solve back all those implications. That's what gives us the internal link to the Mugardi evidence, and now it gives us the internal link to all of the McKinnon analysis as to why we create a broad national scope. This means there is no warrant at all on this list why we don't be able to solve that. Best to be a nice little activism link for you about reinterpreting a broad clause, but if you don't make any arguments, that means we give 100% risk of being able to solve. It means 1% risk that you link to capitalism and you vote that. Shakespeare. The argument made during the 2NC and backed up by the Pope evidence read in the one hour is phenomenal. It's backed up by the Pope evidence talk about why it's not just this one issue. It's an infinite number of issues that are going to come post-plan. Right now, there are lots of people out there trying to fight for human rights. However, in the status quo, they have no mechanism. You have a choice here. You have a choice to say, all those people, you have to justify your human rights based on how well you fit into the cycles of capitalism and commerce in the United States. Or you can say, because you are human, you have these certain rights, and we should not abridge them because you are a person. There is no reason why you prefer the alternative in light of all of the impacts read in the 2NC and the 1NC that are fundamentally dropped in the Pope evidence and the two cannot go together. I don't know if I extended that explicitly on the permutation, but that part also answers the permutation. Says combining the two is net worse because it necessarily ties the Commerce Clause and human rights claims together, makes it impossible for you to divorce the two. Divorcing the two is the only way to allow for a world in which you don't have to subordinate yourself to capitalism in order to solve for human rights issues. Now he says the Commerce Clause is key to change societal opinion. He sends to Johnson evidence, but this Johnson evidence is just not nearly responsive as they need it to be. I'm going to go bullshit on this card. It says nothing like what Ilya explained it. Is this your armor evidence just better? It says it was merely political expediency that led people to argue that the Commerce Clause was justifiable. There's no part of this evidence that says it would actually be good to justify the Commerce Clause or any comparative evidence to make or any comparative evidence to say it's better than ruling on the 14th Amendment. We're the only people reading comparative evidence, and the only people making comparative analysis for the reason for you to vote here. Now I'm going to extend all the resident link analysis that I give in the 2NC that is completely dropped. The specific link analysis about the McKinnon evidence, how it proves that women were not economically valuable enough, and how even if they're right about making women producers, it still makes their production contingent on capital. I.e., if they suddenly become not producers anymore, if they become less efficient in the scheme of capital, that justifies their elimination, which is the link to the criticism. Additionally, you can see that you prefer our resident evidence because the starting point of all our analysis is that we can't do anything about capitalism, but our alternative proves that you can do something about capitalism. Do not resign yourself to not being able to do anything. He says that women are not necessarily commodified. That's answered above, and even if it's true, we're still going to be a better way. So there's still going to be a way to solve. Always, it's only positive to insofar as we're able to capture the gender discrimination arguments simply don't apply. Now on the Flynn alternative, he says it proves the argument is a critical examination. That's fine. I don't need to go for those discourse links. So all I need to go for is the Commerce Clause is fundamentally bad. There's no way they're going to generate offense off here. He doesn't go for any theory evidence to why this is bad. At the point the alternative is going to be able to solve this back simply by not looking at capitalism. There's no reason why they'll be able to solve this back. Additionally, I want to extend the two pieces. Jump back up to the resident debate really quick. They also can see that all of the resident analysis implicitly assumes that it's better to work within the system and make people produce it, and then you can find your way out. That is answered back by the two pieces of conceded. The piece of conceded strategic evidence says that you can grasp the revolution right now, and that is able to solve. Additionally, the next piece of strategic evidence says that taking a middle path of compromise always brings the whole liberal suspicion, which means they can never solve. That means their resident evidence is fundamentally flawed now. They say they talk about different forms of identities. That's fine. We do that too. There's no reason that's offense for them. In fact, we do. All of his arguments here are the same things used to justify the continuation of gender violence. Arguments are going to be the Mazar sentence indicates when you don't look at capitalism, you can create new opportunities. I think you see the strategic evidence talk specifically about why by embracing it in the here and now, you could suspend temporality and not lead to any of the impacts they talk about. Additionally, we control the term uniqueness of the situation, even if everything is true that they're talking about, and the transition away might lead to wars, and the cap might be inevitable, it's still going to lead to violence. They also concede they also concede the Mueller evidence and talk about why capitalism creates hierarchies, means inevitably turns the case. They have nothing to leverage against that. He said transition creates a war functions as an impact. Our first argument is this is only possible in a world where violence happens. We're controlling the term uniqueness in the situation. Additionally, he concedes the analysis of why the former USSR is not a good context. All arguments that you can do not have to deal in the mode of global capital, rather you can deal in the here and now. The suspension of temporality is what enables you to solve our discourse. You can see the discourse is a valuable thing. We need your discourse to be able to break it down. He says history is on our side, but that is all above. He says capitalism never because of the dark understanding. First argument, that's not the warranted argument. Just as socialist revolution may be impossible, but Mr. R. Evidence says taking that leap and saying that it's not impossible that we can do things to break out of it is going to be the solution. It's a question of whether or not you want to it's a question of whether or not you think capitalism is just like the situation. They have no justification for that being possible. Additionally, you can see that the environment impact.
What time do we have here? Like 7:10. Alright, is this something? This is